Tonight on the Daily Debrief, the McStay family said to have been killed by a hammer. Why no blood at the state's suspected crime scene? The defense forces an expert to backtrack. Also, trial is set to begin against a mother accused of leaving her 4-month-old child to die in a swing. Plus, a delay in the criminal prosecution of a college president accused of lying about a national sexual assault scandal. This is the Daily Debrief for Tuesday, January 29th. Good evening, everybody. Welcome to the Debrief. The defense scored key points last night in the case of a California man accused of murdering a family of 4. Charles Merritt could face the death penalty if convicted in the killings of his business associate Joseph McStay, McStay's wife, and the McStay's 2 boys. Authorities at first wondered if the McStays fled to Mexico to avoid business debts, but a dirt biker later located their bodies buried in the desert years after they disappeared. That is when suspicions focused on the defendant, and prosecutors say he killed for money. The question, as always, is whether the state can prove its case beyond a reasonable doubt. For months, the state promised it would present evidence that the victims were killed in their home. Here's the problem. There's no clear evidence of blood in the home. The only thing the state has presented thus far are these tiny pictures of tiny droplets of suspected blood, possible blood. The police testified they didn't even notice the spots until they took their photos back to the police station and enlarged them. By that point, relatives had cleaned up the home and any evidence is gone. The state tried to clear that up last evening, by asking a medical examiner if a brutal attack with a hammer would leave blood at the scene. Here is her opinion.
Now, could an injury like this occur without there being any actual blood that comes out on the outside of the skin?
Yes.
How could that occur?
Because you will have blood coming out of the skin if there was a laceration, an open wound. With a trauma like this, you're definitely going to have external injuries, but it could be a bruise or an abrasion. It doesn't have to be a laceration.
How about some of the other fractures that we looked at with respect to Summer McStay? Is it possible for those injuries to have occurred without external lacerations?
Based on the number of pieces of skull that are broken, you would expect that there would be some lacerations, but not all of the skull fractures need to have an overlying laceration.
Is it possible you could incapacitate somebody to a certain degree without causing a laceration to the skull with blunt force trauma?
Yes.
The prosecutor was very careful to point out the difference between the various injuries and how only a laceration, a cut, would cause bleeding.
Now, I want to be clear about something because we talked a lot about different injuries that can happen to the head. And if I understood you correctly, you indicated that there could be a contusion, there could be an abrasion, or there could be a laceration. Is that correct?
On the scalp.
On the scalp, okay. And the only one that we would see bleeding for on the outside or exterior of the head would be if there's a laceration. Is that right?
Correct.
And because we don't have any tissue here, you're not able to tell us whether or not there was a laceration. Is that correct?
On the adults, based on the injuries on the skull, I would expect that there would be lacerations, but I wouldn't be saying how many lacerations.
Okay. Is it possible to incapacitate somebody or render them unconscious with any one of those blows that you observed to the head without causing a laceration?
Yes.
So it's the medical examiner's opinion that despite the condition of the family's remains, despite the injuries, that the wounds that family suffered might not have caused a lot of blood loss. The defense, though, fought back.
With this type of destruction, I guess, to the skull, as they're saying, you'd expect to see laceration.
With this type of trauma resulting in multiple pieces, I would expect lacerations on the scalp.
And for premature skull was, I guess you'd say, shattered.
Yes.
And this again would lead to the same type of excessive bleeding that you described with Joseph McStay.
It would lead to a pooling of blood, such as Joseph McStay.
The defense went further to pound home the point that 3 of the McStays likely bled when killed.
How much blood would you expect to be around that body at the time of impact?
I wouldn't be able to exactly quantitate how much blood, but it would be noticeable blood. There would be blood around the head and around the body.
And when we say blood, are we talking just a couple of drops, or are we talking it's starting to pool?
It's starting to pool.
This would be something that would be a significant least amount of blood.
Significant is relative, but definitely there will be a pool of blood.
The location to which Gianni Joseph Sr. and Summer McStay met their demise, at that scene, would you expect to see blood at that point?
I would expect blood to be at that scene.
If the bodies were killed at some location and transported somewhere else, would you expect those bodies, even after the demise, to continue to leak blood while they're being moved?
No, because once you're dead, your heart will stop pumping blood. So even though you have injured blood vessels, there's no pressure pushing the blood out.
So it wouldn't come out the head?
Not during transport, it will not continue to flow out.
Well, continue to flow meaning it wouldn't come out in a heavy flow, but would still there'd be some leakage?
It's possible to be some leakage, yes.
Because it wouldn't seal, right? Because the body doesn't heal itself.
It wouldn't seal, but once the heart stops beating, there's nothing pumping the blood out anymore.
The medical examiner seemed to agree that there were likely or possibly pools of blood at the scene, but police didn't find anything to suggest anything like that was ever present at the family's home. So the question is, why did prosecutors promise the murders happened in the McStay family home? The answer might go beyond those little droplets of possible blood.
To you, as an initial investigator evaluating the state of the investigation when you saw that photograph?
That there were no towels inside the bathroom.
Okay. And is this the downstairs bathroom?
That's correct.
Exhibit number 100. Is that the upstairs bathroom?
Yes, the upstairs shared bathroom.
And what was significant about that photograph when you reviewed it?
Again, no towels.
Exhibit 660 in the top left. That is what?
That's the master bathroom, and there's one hook with no robe, and then a second hook with a bathroom on it.
In the bottom left, exhibit number 53, what is that?
That's the downstairs bathroom toilet, where there's a decorative rug chamois on the toilet seat, and no matching floor rugs or any other type of matching set to it.
Did that cause you to look at the evidence that was recovered from the grave sites?
Yes.
Showing you exhibit number 297 as displayed. What was significant about that?
Looking at the fabric and the way it's depicted in the photograph, it appeared consistent with what would be either the bathrobe, if there's one missing from the hook, or from matching rug to the toilet seat cover.
The rug, the towels, adding yet another wrinkle to this case. The trial paused yesterday evening because a juror said his or her stomach was off. That complaint came after a medical examiner showed autopsy photos of the McStay family's remains. A dirt biker in the desert, as we said, discovered the skull of one of the McStays. That led authorities to the graves of the entire family. Authorities also recovered that sledgehammer suspected to be the murder weapon. Police also found a cord believed to have been tied around victim Joseph McStay's neck. Attorney Katie Cherkasky joins us on the debrief tonight. Katie, I thought the defense did a pretty good job forcing the medical examiner to walk back some of her testimony about the amount of blood that the victims likely lost when they were killed. Is that your analysis as well?
Yeah, I thought it went really well for the defense with that. I think the prosecutors had this theory that these injuries could theoretically be possible without blood, but with 4 people, I think that was kind of a tenuous theory to begin with. So I thought it went well for the defense on cross with the expert in that respect.
Yeah, I did as well, but let's talk about the lack of towels in the bathroom and these shards of fabric police found in the graves. This one found in the grave, they're saying, look, that looks just like the missing, presumably missing, rug on the bathroom floor that they presume matches what was on the toilet seat. You know, if you have one of those rug covers on the seat, you probably have something on the floor. And they're saying, hey, wait a minute, this suggests that that item found in the grave came from that family's bathroom. Does that then make the link stronger for the state that these crimes did indeed happen in that home?
I think that's the argument, but I don't think that's necessarily what that means. There could be other reasons that those items were taken from the home when the family was transported, but then again, there would have to be some timeline shown about how they were taken out of the house and how that all happened with them being alive. So it helps, but it's not definitive by any means.
I would agree with that as well. Now, is this just a case where each pebble, each little piece of tiny evidence may add up over the course of months here and equal amount of evidence?
I think that's the state's strategy here. That's all they really have. They have to overcome the burden of proof here, and there has to be enough to really link Charles Merritt to this crime. So anything that kind of goes with their narrative and makes sense and it cannot be easily disputed by the defense is going to help them, even if it's very small.
We will keep an eye and see how long it goes here. The state has argued that defendant Charles Merritt killed the McStay family over money. The two worked together building waterfalls and fountains. This morning, one of the defendant's former employees testified that the defendant, Merritt, did a project of his own using some of victim Joseph McStay's inventory. Here's how the defense dealt with that.
Projects did Joseph and Chase do together while you were there?
Many.
What would you say? More than 3?
Definitely more than 3.
More than 10?
Yes.
20?
Many.
Was it more than 20, do you think?
Yes.
And these were all waterfalls that were built by Chase himself, correct?
And the employees, yes.
And how many other employees would help?
At some point there were three or four.
But they did all the building?
Yes.
And if I understand, your other testimony is that there was an occasion where payroll was not going to be made. Is that correct?
Right.
Okay. And so Chase told Joseph that there was a waterfall that was completed. Is that right?
Yes.
And do you know which waterfall that was?
No.
Do you know how much it was worth? Because you said they're different values, right?
Mm-hmm.
Okay.
Yes.
So, but you said you called Joseph and told him about that, right?
They had a conversation regarding...
Well, my question is, did you call Joseph and tell him that?
Tell him what?
That the waterfall wasn't completed?
Yes.
Okay. But you must have told him which waterfall it was.
Yes.
Which one was it?
Objection argument, asked and answered.
So you don't know which waterfall it was?
Objection, asked and answered.
And you don't know the value?
Objection, asked and answered.
But Chase was trying to get the money from Joseph to cover payroll, including yours, right?
Objection, speculation, misstate the evidence.
Correct?
Yes.
The prosecution did not want the defense to control the narrative on that. Look, the defendant told the police that there was always money moving back and forth between him and the victim's business. Earlier on in this case, one of the victim's associates testified about sending additional money to the victim's business to finish a project. Here is cross-examination.
Your testimony was that you get involved when there's a problem, correct? With the subcontractor?
Yes.
Would it be fair to say that before you contacted Chase Merritt, you had been contacting someone else at Earth and Fire Products, correct?
Yes.
Who was that?
I was going through the emails and the contact information on their website.
And that, do you recall speaking with Dan Kavanaugh?
I do know I spoke with him. I believe I spoke with him after I spoke with Chase.
So the first time you contacted anyone about the waterfalls was Chase Merritt?
I probably called every number on their page emailed whoever I could just to get a hold of somebody.
You spoke to Dan Kavanaugh and Susan Blake as well, correct? Both of those individuals?
I did.
And both of those individuals you spoke with prior to speaking with Mr. Merritt or after, do you recall?
I don't think I talked to either one of them before I talked to Chase Merritt.
Dan Kavanaugh is the man the defense is pointing to here as an alternate possible suspect in these murders. The defense went on along that line of questioning and tried to figure out just who was taking in payments after the McStay family disappeared. Recall that prosecutors are accusing Chase Merritt of having a financial motive to kill the family.
When you talked to the detective, all the money for the waterfall had been paid, correct?
I believe so.
Okay, and you told him that the money was sent to Dan Kavanaugh, correct?
Objection misstates the testimony.
I don't know where the money went. I have no idea.
Then why did you tell the detective that they wired the money to Dan Kavanaugh?
Objection argumentative.
You don't remember telling the detective that we sent half to Dan Kavanaugh and half somewhere else, did you?
No, I don't.
Okay. And as far as you knew, at the time, your company had sent the $12,000 to Dan Kavanaugh. That's what your knowledge was at the time that you spoke to the detective, correct?
Objection misstates the testimony.
Line of inquiry ended without a clear answer. Another business associate, though, faced similar questions about who at Joseph McStay's company was taking in money after the McStays disappeared.
Do you know who she was in contact with at Earth Inspired Products? Were you aware that Mr. Merritt, the person that you were speaking with, and that was sometime later, correct?
Correct.
That he is not an employee of Earth Inspired Products?
Objection assumes facts, not evidence.
Objection to assume exposed for speculation by this witness.
Do you know what Mr. Merritt's relationship was with Earth Inspired Products?
Objection speculation.
If he has a basis.
The conversation I had with Mr. Merritt indicated that he was a partner.
A partner with Earth Inspired Products?
Yes.
Okay. And why would you make the check out then to Charles Merritt as opposed to Earth Inspired Products or the company?
The conversation I had with him, I want my help on this. I need you to pay me.
Still ahead tonight here on the Daily Debrief. We are on the eve of opening statements in the case of an Iowa mother accused of leaving her 4-month-old infant alone to die in a child's swing. We will return after this quick break. Welcome back to the Debrief, ladies and gentlemen. A preliminary hearing has been delayed for the former college president accused of playing a role in the Larry Nassar sex assault scandal. Luanna Simon faces charges that she lied to investigators about her knowledge of the accusations against Nassar. A judge will determine if prosecutors have enough evidence to move forward on the case. Nassar pleaded guilty to federal and state sexual abuse charges after more than 100 people came forward against him. A hearing in the Luanna Simon case is now scheduled to start next week. The trial of an Iowa mother accused of murdering her baby is set to kick off tomorrow if a mix of wintry weather does not cause problems where the trial is being held. This case will be the second involving the death of the infant Sterling Cheyanne. The mother, Cheyanne Harris, will face a jury starting tomorrow. The father, on the left side of your screen, has already been convicted. The state is now pressing for yet another conviction on Iowa law, which says endangering a baby to the point the baby dies is murder. Zachary Cheyanne took the stand during his own trial and mostly blamed Cheyanne Harris, the mother, for his son's death. Here is some of the cross-examination in the first case.
That Sterling's death is all the fault of Cheyanne Harris. Now, you're saying that you have some responsibility? If I would have known, yes, I do. So you're saying that what you did wrong is you didn't know.
Yes,
You told this jury that you used methamphetamine, right?
that's correct.
But you told them the only reason you did it is to stay away from work, right?
Yes,
You told this jury that you gave Cheyanne Harris methamphetamine, right?
that's correct.
But the only reason you gave it to her is because she became difficult if you did it, right?
That's correct.
You told this jury that you used your company's credit card without authorization, right?
Yes,
But the only reason you did it is to feed your family, right?
yes,
You told this jury that you didn't change diapers because you had a weak stomach, right?
that's correct.
And you couldn't handle the smell of feces, right?
Yes.
But you worked at a manure hauling company?
Human feces and animal feces are different in my nose.
Your nose is that refined?
Of course.
And it's testimony like that that resulted in a conviction in the first case. Back one more time on this one to attorney Katie Cherkasky. Zachary Keyan said there, Katie, that this was mostly Cheyenne's fault because he was out driving a truck, working long hours, while she was the stay-at-home caregiver. But he also tried to say she was suffering from depression. Could that possibly be part of her defense?
Well, the evidence that we've seen in this case is that the child was severely neglected for a very long period of time and not something that was just a temporary, during the day I didn't know what was going on situation, or, oh, I was depressed, that's why it didn't happen. And in fact, that may be part of what the defense presents on her behalf, but it's not going to mitigate the endangerment charge. That's the problem for her. So the facts really just cut against them in all regards.
Yeah, we've got
they've kind of contradicted themselves.
We've got a few seconds left here. Harris has filed some court documents suggesting a possible diminished responsibility or intoxication defense. Is she trying to say she was so drugged up here that she simply didn't notice, couldn't process the intent to commit the crime here?
I don't think that's going to take her very far because, again, the timeline just doesn't make sense, and there's been contradictory information from what I've seen on her drug use and on the history with that. So, again, it's kind of a last-ditch effort by the defense, but I don't think it's going to overcome the evidence against her in that case.
I agree as well. Look, the defense has to press the tactics it can press. Katie, appreciate your analysis here on the Debrief.
Thank you.
And thanks for watching again, ladies and gentlemen. I'll see you back here on the Debrief, either at 4 o'clock or 5 o'clock on the Law&Crime Network. Our schedule here depends on testimony in the McStay case. For some of you, I'll be sticking around for continued coverage of that case.